Ms. Rahayu?
Mr. Deputy Speaker, I declare that I am a lawyer in private practice. Allow me to begin my speech in Malay. Salah satu prinsip penting dalam sistem perundangan Singapura adalah akses kepada keadilan atau access to justice. Ini bermakna seseorang itu sepatutnya berhak mendapatkan nasihat guaman dan mengetengahkan kesnya ke mahkamah, tidak kira latar belakangnya atau kemampuan keuangannya. Hak ini tidak patut dihambat oleh kos guaman yang tinggi atau proses-proses pentadbiran yang kompleks. Maka itu perlu sentiasa ada usaha untuk memastikan adanya sokongan untuk mereka yang memerlukan bantuan guaman. Di Singapura, kita ada klinik-klinik guaman di mana orang ramai boleh mendapatkan nasihat guaman am yang percuma. Kita ada biro bantuan guaman yang boleh memberi bantuan untuk kes-kes sivil seperti kes perceraian dan juga skim bantuan guaman untuk kes-kes jenayah. Saya juga tahu ramai peguam yang kadang-kadang mengambil kes secara percuma atau pada kos yang amat rendah untuk membantu klien mereka yang mungkin mempunyai kesulitan untuk membayar kos guaman yang penuh. Bantuan-bantuan yang saya sebutkan tadi sedikit sebanyak membantu mengurangkan kerisauan tentang isu akses kepada bantuan guaman. Namun masih ada lagi cabaran-cabaran tertentu yang boleh diperhatikan. Hari ini kita membincangkan secara khusus rang undang-undang untuk bantuan dan nasihat guaman yang akan menjadi panduan pentadbiran bagi Biro Bantuan Guaman yang mengendalikan bantuan guaman untuk kes-kes sivil. Antara keprihatinan yang timbul adalah proses memeriksa kemampuan seseorang sebelum bantuan guaman boleh diberikan oleh Biro Bantuan Guaman. Kini, semasa membuat permohonan untuk bantuan guaman, banyak perincian yang perlu diberikan dan dokumen-dokumen yang perlu disiapkan. Proses ini membebankan. Ianya juga memakan masa dan menyebabkan proses pemeriksaan ini menjadi lebih panjang. Dalam rang undang-undang yang dibentangkan kini, ada saranan untuk mengadakan kriteria baru yang telah dikemaskinikan dan akan mempermudahkan permohonan bagi bantuan guaman ini. Saya menyokong saranan ini. Diharapkan dengan kriteria baru, proses permohonan boleh dipercepatkan. Saya juga harap ada penelitian tentang kriteria yang akan ditetapkan agar lebih ramai boleh menerima bantuan. Berikutan dengan ini, satu hal lagi yang sering ditimbulkan adalah kelayakan untuk mendapat bantuan guaman. Masalah guaman bukanlah sesuatu yang diingini dan seringkali tidak dijangkakan. Maka itu apabila seseorang itu terpaksa memulakan atau mempertahankan kes di mahkamah, kos guaman mungkin sukar ditanggung walaupun dia bukannya seseorang yang berpendapatan rendah. Buat masa ini, Biro Bantuan Guaman terhad dengan akta yang sedia ada dan hanya boleh memberi bantuan kepada mereka yang menepati kriteria yang ditetapkan. Saya gembira adanya perubahan yang disarankan iaitu kelonggaran atau discretion untuk memberi bantuan kepada mereka yang mungkin tidak menepati kriteria yang ditetapkan secara penuh namun amat memerlukan bantuan. Tentu sekali perlu adanya panduan dalam mempraktikkan kelonggaran ini. Besar harapan saya agar kelonggaran ini dapat digunakan dengan bijaksana dan dapat membantu lebih ramai orang yang mungkin menghadapi masa-masa yang sukar dalam kehidupan mereka. Mr. Deputy Speaker in English. Access to justice regardless of social standing or financial ability is a cornerstone of our legal framework in Singapore. Efforts must be made to overcome issues of cost, delay or complexities of the legal system that may hinder access to legal advice or the ability to present one's case in court. In Singapore, we have legal clinics, the Legal Aid Bureau and the Criminal Legal Aid Scheme to partly address the need for access to justice. I also know of lawyers who would do pro bono or low bono work to assist clients who may not be able to afford legal costs. However, there are existing challenges within the current framework in the provision of legal aid and advice. Therefore, this bill is a welcome move and the opportunity to discuss this matter today is much appreciated. One of the issues often raised is the means testing process that is currently in place. The assessment process calls for much information and numerous documents to be provided. This can be overwhelming and daunting for the applicant. At a time when they most need help and are most slightly preoccupied with significant matters happening in their lives, the requirement to prepare copious documents before they can get help adds to the stress. This requirement often also delays the process because the applicant would need to set aside time to look for and prepare the documents. I am therefore very pleased to note that the bill proposes to give the Ministry the flexibility to establish new means criteria to be set up in the subsidiary legislation. I note the Ministry's efforts in reviewing the means criteria to update and simplify the criteria. I also note that the plan is to align the means criteria to those commonly used in current social support schemes. While I understand and agree with the need for alignment, there are already concerns with the existing means criteria. For example, in determining per capita household income, PCHI, we have heard some grievances of those who have children or relations living in the same address but not contributing to the household income. Also, in considering the annual value of a property, it would be pertinent to note that there may be people who are residing in a private property, not as a luxury, but because of their circumstances. These grievances may be adopted if we take the PCHI and the annual value assessment methods wholesale. Would there be some way of addressing some of these issues head-on and provide for appropriate deductions or exceptions at the outset? I'm not suggesting that the assessments are made less rigorous. I believe it's important to check properly and only grant aid to those who truly deserve it. However, if we already know that the applicant may be facing some difficulties, perhaps we could account for these situations subject to the provision of some basic evidence. The other issue that is often raised as a pain point is the eligibility for legal aid. Could there be adjustments to the limits of the prescribed means test to allow for more to qualify for legal aid? Having legal troubles is not something one often plans for or expects. It is not a habit to set aside savings for legal costs. So when there is a need to commence an action or defend a case in court, it is common to hear of situations where the individual is financially stretched and have difficulties financing their legal costs, even though he or she may be earning a decent income. In recent times, there have been calls for more legal assistance to be given to the sandwich class. I appreciate that a line has to be drawn somewhere and we will not be able to help everyone. However, we should endeavour to help as many as possible, and we need to look at some measures to be able to address this gap. I'm therefore grateful that there are provisions in this bill to give the Minister discretion to grant legal aid if it is deemed just and proper. I believe there will be guidelines for the proper exercise of this discretion. I'm hopeful that this discretion would allow for more deserving applicants to receive help, even though they may not meet all the prescribed means requirements. On a separate note, in the effort to enhance access to justice and close the gaps, I believe one strategy is to encourage and incentivize low bono efforts by lawyers. We have already many lawyers doing pro bono work, but this often comes at a cost to the lawyer's earnings. I know people joke about how much a lawyer earns, but the truth is that not all lawyers are mercenary and not all lawyers earn big profits. A law practice is also a business and would have overheads and operational costs just like a medical practice or other professional services. In fact, the legal fraternity also has to go through industry transformation like other industries in Singapore. Bearing this in mind and considering the need to close some gaps, we may therefore want to cast our sights on a more sustainable solution that could be a win-win solution for all. At the opening of the legal year this year, Chief Justice Sundaresh Menon proposed a family law assistance scheme. The idea is to develop a low bono model to increase access to legal services for those in the sandwich class who are embroiled in family disputes. This is a meaningful suggestion which is being looked into, and there may also be a further need to incentivize lawyers with continuing professional development or CPD points to recognize them for efforts in pro bono as well as low bono work. I hope that there will be more support in thinking about and developing such pro bono, low bono models that could allow for more to benefit from getting proper legal advice and aid, but which could also support the legal sector. Mr. Deputy Speaker, I believe that this bill is a step in the right direction. I stand in support of the bill.